Hi, yes, I'm Christopher Olson.
Thank you, Mr. Olson, for being present. So as I understand the history here, and I'm going to call you Ms. Steinweg, but it's somewhat confusing because the court, you haven't filed a formal name change on your case, so you're still under Tiffany Johnson. But Ms. Steinweg, you had put this on. There was a previous finding by a judicial officer of adequate cause. The judicial officer had sent you all to mediation. Mr. Johnson, you had failed to appear, or excuse me, Mr. Olson, you had failed to appear for that. So this got put on for trial assignment on a new parenting plan. Ms. Steinweg, as I understand it, when you went to trial assignment, you were not able to get that date assigned because the judicial officer let you know essentially Mr. Olson was in default status since he hasn't filed a response.
Correct.
So you did file this motion for default, which is in accordance with what happened at your trial setting. Since that time, Mr. Olson, you have filed a response to the default. I did receive your declaration affidavit of September 14th, indicating your reasons for non-appearance previously in this case. So
is that supposed to be served to me as well?
It should be. Mr. Olson, have you served that on Ms. Steinweg?
No, I just to the courts.
Okay.
Kind of been a confusing process for me.
I understand. In moving forward through these processes without an attorney can be confusing. What I'm going to first require today, I'm not entering default today because Mr. Olson has appeared. The law favors judgment on the merits. When someone has appeared despite prior non-appearance, the court generally will not enter default. However, Mr. Olson, essentially that means kind of this is your kind of last attempt to not go into default. So I'm going to set you all a new review date with this court. And by that date, I need you to file a response to Ms. Steinweg's request. But I also want to ask the two of you, do you want to be referred back to mediation?
Your Honor, I'm at the point where he has been requested to do mediation, hair follicle test. He has not done anything that has been requested of him.
Okay.
And now, the weekend before last, my son was in an accident where he was at his house and suffered a serious concussion. He's not following the doctor's guidelines. It's
Okay. So let's do this then. Has he been served your proposed parenting plan?
Yes, back in March, I believe.
I see that March 30th. Okay. Mr. Olson, do you have the proposed parenting plan from Ms. Steinweg from back in March?
Yes.
Okay. I'm going to set a review date. If you all are available next week, I'm just going to give you 1 week because this has been going on since March. I'm going to give you 1 week to file a response to the proposed parenting plan. Otherwise, I will again entertain Ms. Steinweg's motion for default. So I'm going to give you until October 4th, well, really October 3rd, to file a response on Ms. Steinweg and this court as to your position on the proposed parenting plan. I want to be really clear. If you don't hit that deadline, I will entertain another motion for default, and it would likely be granted at that time. If, however, you do respond, then when we come together next week, I'll get you both set on the trial
Yes,
assignment.
Your Honor,
calendar.
fellows GAL present.
Good morning.
Morning.
Do I have Mr. Weiss? I think I saw you log on.
Yep.
Okay. And do I have Ms. Shoemate?
Yes.
Okay. I had you all on for pretrial management. I believe you all are still set for trial the week of October 9th. Is that correct?
Yes.
Okay. Ms. Shoemate, when we were last here for readiness, pretrial, you were unable to participate, is my understanding. And there was a discussion at that time about next time you were here confirming the issues for trial. Does anybody want to jump in?
Yes, Your Honor. This is the GAL. This was classified as a modification of a parenting plan. However, throughout the course of this case, there's never been a final parenting plan signed with the court and filed. So in reality, this needs to be reclassified as a trial for final parenting plan. And I wasn't sure if there could be an agreement to go ahead and just reclassify that, or if it needs to go back to the trial assignment docket.
I don't believe so. I think what my hope was is that with agreement of the parties, Mr. Weiss and Ms. Shoemate, there would be a record today on the clerk's minutes that you are both in agreement that the issue for trial is your final orders.
I'm in agreement with that. Yes.
And Ms. Shoemate,
I think that's what we agreed on for trial.
okay. And then Ms. Looney, is there any position from the state?
The state would be in agreement with that as well, Your Honor. We're ready to move forward with trial.
Okay. So Mr. Weiss and Ms. Shoemate, since you are unrepresented, this is pre-trial management. Do you both feel as though you're ready to proceed to trial the week of October 9th?
Yes.
Negative, Your Honor.
Why do you say negative?
Well, I was kind of hoping to get a copy of the GAL report so I can provide the proper paperwork to back up all the findings in it. And between today's date and October 9th, that's just not enough time to get it all together and get the other party served. I would like a copy of all the GAL information so that I can provide proper paperwork and get it served in a properly timed manner so I can get ready for trial.
And Your Honor, if I could address that.
Yes.
I have been working on the GAL report. Excuse me. And it has taken me longer. There's more details in it that I've had to add to it. My plan, and what I will do is I will file it before the end of the day tomorrow, Thursday, September 28th. And I will email both parties as well.
So I think, Mr. Weiss, if that GAL report is to you by the end of the day tomorrow, at this point, I'm not going to strike trial for week of October 9th. You do all have trial readiness scheduled on October 3rd. So if you get the GAL report tomorrow and you feel like you still need additional time before trial, please let the court know on the October 3rd readiness docket. I guess my only, I can't give you legal advice, but I don't know what you mean by you have to serve it on other parties, because Ms. Shoemate is going to get a copy just like you are.
What I meant by serving is I need the documents to back everything that the GAL has said in her report on my behalf. So, and I'm pretty sure I have to serve Ms. Shoemate with what I'm bringing to trial.
Yeah, and this case has been going on for so long, even just in front of me, let alone a prior judicial officer, that I, at this point, have a hard time believing you wouldn't already have all that information. So I'm going to go ahead and keep trial for October 9th. Again, if you get the GAL report tomorrow and you still feel like you're not ready to move forward, we can address that at your October 3rd readiness hearing, okay?
Sounds good.
Okay. Anything else on this case?
I don't believe.
What time is the trial readiness, Your Honor?
Let's see, trial readiness is October 3rd at 11:30 via Zoom.
Okay, thank you.
Of course. Anything else? Okay. I'm not going to set a review date on this case since you are going to trial. If for some reason it is struck at readiness, we'll get you back on this calendar and move forward. Yeah, I had received proposed orders, but the state hadn't yet been served the documents. And I know part of it appeared to be modification of child support. I don't see anything new since we were last here on August 23rd. What can the parties tell me?
Well, we haven't been able to discuss that and get whatever paperwork needs to be done and served. And I talked to Heidi this morning.
Let me just hold on 1 second. Do we have Heidi online with us?
No.
Is Heidi Entler, well, now Johnston, online with us?
No.
Yeah, I don't see her. Okay. And Ms. Looney, I assume your office has not been served with the paperwork?
We have not, Your Honor.
Okay. So Mr. Entler, go ahead. You were in the middle of kind of filling me in on where we're at.
Well, I talked to her this morning. First time I talked to her in probably 2-3 weeks. That she's been busy with work. And then she said this morning that she was going to try to get on for court. And if she can get on, but apparently she wasn't able to get off the floor. So she just said that she hasn't had time to get it done. So, and that she would call me after work. That's just all I know.
Okay. And Ms. Turnbull, I'll ask for any input you have. I'll just state my only concern in this case was you both, well, Ms. Johnston isn't here. Number one concern. Number two is y'all were scheduled for trial and told the judicial office at that time that you had come to an agreement. So the trial was struck, but it seems like we're not making too much forward progress since that time. But go ahead, Ms. Turnbull.
Yes, I think that they are in agreement, but I suspect that without the pressure of the trial that Ms. Johnson has maybe put it on the back burner a little bit, and she is busy with the children and work, and maybe hasn't taken the time to make it a priority.
So Mr. Entler, I could offer you another set over to allow you and Ms. Johnston time to get these things done. I would probably say it would be my last set over before I would essentially just strike the matter and you guys would have to renote it on this docket when you're ready or set it for trial again. What's your preference?
See if we can get it set over a little bit and then I can get with her today when she can stop work and figure out what's going on. Because I know she's been tied up with 3 of the kids with games and work and then their counseling appointments and then I don't know, it's just been pretty busy the last few weeks. So
okay, let me do this. And Ms. Turnbull, does October 18th work for you? Essentially 3 weeks.
Let me just check real quick.
Okay.
Your Honor, if I could,
Yes.
I just wanted to remind Your Honor and the parties that you had ordered that they need to speak with the court facilitator before they can enter anything, and that does need to happen before any case can be finalized. So I don't know how far out those appointments might be.
That is a good point. And I assume, Mr. Entler, you have not met with the courthouse facilitator to go over the paperwork since you guys don't have the final paperwork.
well, she has paperwork from last court we agreed on, and then I guess something got messed up or whatever that she had to change something or whatever. And then that's all that's holding up. I mean, she has the paperwork. She just, I don't know what.
Well, I mean, essentially what happened was you all submitted just a declaration telling me what you wanted your parenting plan to look like. That's not final orders for my review. So there is some work that needs to go into this. Let me ask the clerk, do you have any idea how far out the facilitators are setting right now? About 2 weeks. Okay. So even if you all reached out to them now, probably the 18th is a little unrealistic. What if we set you for Wednesday, November 1st? That gives you about 5 weeks to get this done.
That'll work.
Does that sound a little more realistic to the parties? And Ms. Turnbull, are you available?
I am available.
Okay, thanks, Ms. Looney, for pointing that out. I think that's a very valid point. So we'll get this renoted for November 1 for presentation of those orders. Mr. Entler, as you and Ms. Johnston are working through this, just make sure you're still preparing the proper paperwork, meeting with the courthouse facilitator, and then serving the proposed orders on Ms. Looney's office. Okay. Okay, anything else on this matter?
No, I was just writing this down, November 1st for what time?
Lawrence, oh, there you are. Good morning. Sorry, I have 2 pages of Zoom screen, so I'm not seeing everyone right away.
Yeah.
Okay, so we did, last time we were together, we talked about, I had issued an order granting or finding adequate cause I think that we also had issued an order needing more investigation from the GAL before we moved forward with a new parenting plan or trial on the new parenting plan. So I guess first, maybe Mr. Lawrence, I'll check in with you and see where we're at.
Well, Your Honor, as you are aware, there was an allegation and a police investigation earlier this summer whereby John and his current wife, Brenda, got into a heated argument, and she alleged that John had assaulted her. He was not charged with that. And there were a lot of issues, and Brenda suffers from some mental health issues. And the question was whether or not it was safe for Max to be there while the two of them were fighting. And John had indicated that Brenda was no longer living at the residence. And so on September the 12th, I made an unannounced home visit, and Mr. Gilbert met me out in the front yard and indicated that Brenda was indeed living there with him now, and that she is undergoing mental health counseling and I believe drug and alcohol counseling as well. The court had ordered Mr. Gilbert to get a psychological evaluation with a parental risk component, and I provided him with the contact information for Dr. Stephen Maharg at Northwest Psychological, and that's pretty much where we're at this point, because I haven't heard whether Mr. Gilbert has an appointment for that evaluation.
Okay. Thank you, Mr. Lawrence. I appreciate that. Mr. Gilbert, what can you tell me about the court-appointed psychological evaluation?
They're months out, and right now we just got out of fire season. Money's tight. We've been shut down, and I know looking outside, you wouldn't believe it, but we've been on a level 2 all summer long, level 3, and shut down. So with that, I would like to know what evaluation could be next. Like you said, this cases are going on forever. I was court ordered to do the hair test and a drug evaluation, clear back in like January. I don't do drugs. I never have. Everything came back negative. The hair sample, the evaluation, nothing needed, everything else. And now all of a sudden, this evaluation. So after this evaluation, what is next?
So that I'm not addressing that, what's in front of me today is whether you have complied with my August 16th ruling that you obtain a psychological evaluation with parental risk assessment. So are you letting me know that for whatever reason, and I certainly understand there are reasons, are you telling me that that has not been scheduled yet?
It has not been scheduled due to financial difficulties.
Okay. When do you think you'll be able to get that scheduled?
I don't know. How long does the supervised visitations? I get those, and that's another $400 a month. It costs me $100 for 2 hours to see my kid. When does that end?
So, sir, you're answering a lot of my questions with questions of your own. That is that's not my role in these proceedings. My role is to ask you the questions. So the question I'm asking you is, when do you think you will be able to get the psychological evaluation scheduled?
As soon as we get back to work and stuff, I will try.
Okay, so can you estimate the length of time that may take? And I'm asking so that I can get you back in court as quickly as possible once you do have that done.
I guess a few weeks.
Okay, let me turn to Ms. Gilbert. So Ms. Gilbert, at this time, the only thing I can do obviously is keep our bench orders regarding suspension of in-person visitation in effect. So I'm not going to be making any changes. Everything's going to remain status quo. So Mr. Gilbert can get that done. What would be your request for timing to come back to court, or do you have a preference?
I don't have a preference. I mean, I don't understand why he can't schedule it if they're months out and then, or, get it on scheduled now.
Yeah.
If it's months out, he doesn't need the money now to schedule it. So.
Okay. So what I'm going to do
Can I
is,
please ask something, Your Honor?
Mr. Gilbert, go ahead. I didn't catch your statement.
Can I please ask? So with the hair follicle test that was ordered, that evaluation that was ordered, those come back negative. If I do this evaluation and it comes back, I have no issues, what can be ordered next?
Mr. Gilbert, what I'm telling you is, I don't have a crystal ball. I don't know what that evaluation is going to show us. It's been recommended because there are enough allegations that your child may have witnessed violence in your home. So our overriding goal is always what is in the best interest of your child. To that end, we've asked for this evaluation. Once I've had a chance to review that and the GAL has had a chance to review that, we will come back and talk about it and where we go from there. But that really is the next step. So what I'm going to do, sir, is I'm going to set this for review of compliance with that evaluation 4 weeks. I don't think it's going to happen before then. I'm pessimistic it will happen by then, but I don't want you all to be in limbo. So I'm going to set this to Wednesday, October 25th at 9 a.m. back on this family law A docket. Does that work for the parties?
Yes, for me.
Okay. Mr. Lawrence?
Yes, it works for me, Your Honor.
Okay. And Mr. Gilbert?
Yes, it works for me. But when I talked to the GL, he said Max didn't witness anything at the house. So he never did see no violence. There was nothing there. The parenting plan proves that. On the dates that the police reports were done, the parenting plan proves that I didn't have Max. I didn't take Max to my house when I had him.
Okay. All right, Mr. Gilbert, what I am talking about right now is you getting the psychological evaluation before we can move forward. Hopefully you can get that done, or at least a scheduled date by October 25th. And we'll see you all about October 25th at 9 a.m. The adequate cause motion. This is an instance where when we were together last, I did not make any specific ruling on that because Mr. Fike, you indicated that same day when we were last together, you were having a conference with Kaiser and Social Services. And you potentially thought that you might be supplying information to the court after that conference. I'll just let the parties know that the only thing I've received since then is a declaration affidavit of Ms. Manley regarding her interactions with the social worker from Kaiser and correspondence from CPS stating that any investigation into Ms. Manley is closed with no findings regarding the allegations. Is there anything else I should have, Mr. Fike? Did you intend to file anything?
Well, I intended to, but when I spoke with the doctor that evening, he told me that he was going to have social services call me, and that never happened. So I called social services. They told me that the doctor can't get them to call me in a case for whatever reason. Anna indicated that she talked to social services at Kaiser. There is no social services at Kaiser. I spoke with them and confirmed that. So there has been no social worker involved. The case of CPS was closed. And as far as I was told with my conversation with CPS, that was actually the findings from my house. So it doesn't actually indicate where the case was being closed from in that letter. It just says that it was closed. And when I spoke to CPS, the lady told me they were the findings from my house. So I'm not really sure. It's all very confusing.
Okay.
I've been canceled 3 times now by the doctor and trying to have a conversation with him to find out what's going on. And apparently Miss Manley has been able to get a hold of them, but I have not.
Okay. So Ms. Manley, go ahead with anything you would like the court to know. I'm just first dealing with Mr. Fike's motion for adequate cause to change a parenting plan.
I had the social worker from Kaiser. She called me and we talked about the whole situation, and she said her only concern was Mr. Fike's behavior. And as far as the CPS report goes, that's the findings from the drug test and the investigation to my home that they did because of Mr. Fike's allegations.
So I have reviewed in So I have reviewed the filings from CPS. Mr. Fike had indicated he thinks that these are related to any investigation on his home. I don't find that to be accurate. I find that it's specifically addressed to Ms. Manley and indicates that her case is being closed with no findings regarding the allegations. I also understand Mr. Fike is asserting to the court that there is no social worker at Kaiser. I don't find that to be accurate, as there are text messages from the Ms. Childs, the quote, social worker from Kaiser, specifically to Ms. Manley. So I think the totality of these circumstances, in addition to the prior concerns I've had with regard to Mr. Fike re-raising allegations that were already addressed by a GAL, is that I'm going to deny the motion for adequate cause. I have filled that out. I'm specifically making a finding that there are not valid reasons to hold a full hearing or trial on the petition. The petition for adequate cause should be dismissed, and I have signed an order to that effect. So we're not going to hold any further hearings on the adequate cause motion. Oh, maybe I'll just. So let's move to contempt. When we were together in prior hearings, I'll just note specifically that Mr. Fike had moved for contempt findings against Ms. Manley. I had already denied that finding. They were not violations of the parenting plan. However, there was a contempt motion by Ms. Manley alleging back child support. What I have received is a response from the Cowlitz County prosecutor indicating that the child support arrears are owed to the state of Washington and not to Ms. Manley. So, Ms. Looney, are you taking any position beyond what was already filed on August 29th?
No, Your Honor.
Okay. And I assume the state is not filing its own or has not filed a motion for contempt at this time?
We have not, Your Honor.
Okay. So Ms. Manley, I also, because of the state's filing and that the arrears are actually owed to them, I do not find you would be the proper party to bring this action. Therefore, I am going to deny your motion for contempt against Mr. Fike as well. Do the parties, as far as I can tell, that takes care of all the issues that have been in front of me for the last few weeks. Is there anything else the parties believe hasn't been addressed that you have previously filed and asked the court to address?
Yes. I also filed contempt regarding my attorney fees that was put in place on 6/7/2021 that Mr. Fike owes me, with interest that's now up to $1,240. There's also the matter of fact that he withheld Liliana from me on 8/30.
Oh, it's included in your child support contempt order.
Yes.
Well, Mr. Fike, have you reimbursed $1,000 in attorney fees?
No, I didn't know I was supposed to. When she filed that was the first I had heard of it. I never got any email indicating that I owed anybody money.
I'm looking to see, Ms. Fike, what's the date that you indicate the judge ordered?
It was 6/7/2021.
This was a contempt hearing.
The only thing, Your Honor, I was given at the end of that trial was after the order, her attorney had filed for additional reconsideration, and that was denied by the judge. And that's the only thing that I've received after the fact.
Yeah, so Ms. Manley, I'm going to deny that request, and it's not because I don't think that he doesn't owe you the $1,000, but what you're referencing in 2020 is a contempt order. So the court has already ruled on this issue. They held a contempt hearing on June 7, 2021, and specifically made a finding that he was in contempt for failure, or excuse me, Yeah, they actually stated he was not in contempt, but they awarded you $1,000.
Was I there for that one? Because I don't remember that.
6/7/2021. Yes. Parties present. Ms. Bliss was the attorney, I believe, representing Ms. Manley. You were present as the petitioner in the proceedings. Your guardian ad litem was there, and there was a deputy prosecuting attorney there, Ms. Wade. Okay, so I'm going to go ahead and deny Ms. Manley's motion, but Mr. Fike, that 2021 judgment is there. There was an actual contempt hearing already on that issue. Okay.
Okay.
And then Ms. Manley, you said your other contempt hearing or contempt motion is based on Mr. Fike withholding Liliana from you on, is it August 23rd?
It was August 3rd. It was on August 30th when he was ordered to take her to get her dental treatment done. And the treatment was not done that day. And instead, Mr. Fike took Liliana to his home and kept her all day.
I'm also going to deny this motion for contempt. In reviewing the pleadings, it does not appear that this has been an issue that has recurred, and it looks like Mr. Fike's likely explanation through his filings was his concerns about her safety and welfare. I'm not condoning the behavior in any regard, but I'm not going to find that it was done in bad faith. So I'm going to deny. But what I'm going to say is I will entertain future motions for contempt if, now that Mr. Fike is aware that this court has specifically made findings that Ms. Manley is not in contempt, CPS has closed their investigation, and it appears from everything I have that the doctor's office is actually concerned about Mr. Fike's behavior, not Ms. Manley's behavior. If there are further incidents where Mr. Fike is not adhering to the parenting plan, I will entertain motions for contempt. Okay, anything else the parties need addressed on your matters?
Well, it is, I don't know if it's contempt per se, but I do have some issues with Mr. Fike trying to alienate me from Liliana's doctors.
Right, so let me just say this. This court is not in a position to solve every unfortunate family dynamic. I don't have a motion in front of me that in any way addresses. I have allegations that you believe that the doctors have said that he's alienating you from her care. If you want to file something that's an actual standalone motion for contempt on that issue, we'll address it, but that's not in front of me today.
Okay.
All right. Thank you both. You're free to log out.
Thank you.
I'm here.
Okay.
I'm here.
Okay, so I'm looking back, you all were in front of Judge Fassett on August 2nd regarding the contempt motion. And my understanding of Judge Fassett's ruling, but please correct me if your understanding was different, is that the court ordered a minimum of $350 to be paid by September 15th at 9 a.m. And then if there wasn't that payment made, the judicial officer was inclined to sign the contempt order. What can that please tell me?
That is correct. And I was able to make that $350 payment, and I sent it through Venmo just so that I could keep track of it. But that payment was made, and that was the ruling. Yes.
Yes, it was paid September 14th. But the other part of that ruling was that she had to communicate with me a payment plan for owed daycare fees, which has not been done.
Okay, so I do see that. So, and I do see the judge discuss that. So let me talk about that in just a minute. The only issue that the judge was going to, based on my review, was to order contempt on was the $350 payment by September 15th. But the judge did also talk to the parties about the child care payment plan. Where are we at on that?
That I completely misunderstood because I thought that I had to make that $350 payment. And then at this court date, I thought we were supposed to set up a plan for the payments thereafter.
Okay, well, I think that that wasn't quite my understanding, but I do believe the judge wasn't inclined to order contempt on the child care payment plan discussions. So at this point, what I'm going to do on the contempt order is deny because payment has been made. Now, sir, please know if there are future non-payments, you can always bring new contempt motions. This just applies to your prior contempt motion.
Okay.
And I don't think, did they submit a contempt motion? It doesn't see. I'll just do a bench order denying the contempt since I don't see an order here. Or I could might create the contempt order. Just going to make a note for myself so I don't forget to get that done for you all. So let's talk about the payment plan for childcare expenses. And then we could set a review date to make sure that everyone's adhering to that. So, sir, I'll turn to you. What is your request?
So I don't want to be unreasonable at all. I do understand now that we have alternating pay dates for childcare moving forward. So I have asked her to communicate with our childcare provider, Cynthia Saunders, personally on setting up her own $100 biweekly payment so that it aligns with her pay dates and I'm not asking more than what she can actually give.
Okay.
But if she could include that just with her monthly $50 child support payment, I feel like that aligns with her pay dates, if I'm not mistaken. And even if it's, $100 increments at a time, it pulls that, I think we're at $1,230 now that she owes. So I'm not asking for an unreasonable, $500 a month payments, just what she can feasibly do to break that down while maintaining current payments.
Okay.
So I have a quick question about that.
Yep, hold on just a second. So let me make sure I understand everything, especially since I wasn't here at your first hearing on this. Sir, you are stating there's retroactive past childcare expenses that you've had to cover because she didn't pay her portion. And so she needs to make arrangements. We need to figure out an amount to start paying you back for those portions. And then you're asking her to work directly with the childcare facility on the current amount owed every 2 weeks. Is that right?
Yes, unless she would rather give that money to me, I am more than happy to pay it. I see her every week, so I can do that. Would be her preference. I felt like she may prefer to work with her on her current pay.
So yeah, Ms. Smiley, go ahead.
Okay, so first, I don't mind paying him directly as long as it's like tracked like through Venmo or something like that. But just because I'm savvy, and it took a lot for me to even learn Venmo. So, but I also just wanted to ask a question. So he said the 100 a month, is that okay? So the 100 a month would go to Cynthia, that he doesn't mind if it goes to him. Is that 100 a month or is that 100 every check? I just want to be sure.
That would be 100 every check. I pay 200 biweekly to her for her school year.
Okay, so 100 every check, now, so every 2 weeks, and then
that's for the current. And if I understand, that's for the current. So that's the amount, ma'am, that you would either be paying directly to the childcare facility, or if you want to pay it to Mr. Smiley, then you can and just keep record of it.
Okay, and then the $50 a month for child support, and I could do an extra 50 every check to try to pay off the back pay.
Mr. Smiley, is that acceptable to you?
Yes, so from my understanding, that would be that $100 a month payment just broken up into two. As long as it's listed separately than what is being paid when she pays $1 fee.
No, so
hold on. let me repeat what I think it would look like, since I'm the one who would be doing an order. So my understanding is that there would be we'd have current obligations owed, $50 a month child support, and then $100 every 2 weeks, per pay period, towards childcare that can be paid to the childcare facility or to Mr. Smiley. So that's your current obligations every month. Then I understand that the past childcare bill that is due to Mr. Smiley that he's had to cover, you would pay him $50 every 2 weeks or every pay period to start paying off that $1,200 and some dollars, I think, in back childcare expenses. Is that your understanding, Mr. Smiley, of your request?
Yes.
And
I would just ask those to pay Miss Cynthia instead of myself to please have that in clear communication for record.
yeah, Ms. Smiley, is what I've just stated something that is doable for you?
Yes. So 100 every check. So I'm thinking on the first, every other check I'll do 150, and that would, every other check I'll do. Okay, I'm so sorry. So 200, just say 200 for the first check, and that would be the 100 for the back pay, 50 for child support, and then 50 for the every 2 weeks that I need to pay back. And then the next check I would do 150 for the 100 for the child care, and then the 50 for the back pay.
That is my understanding. So if that's how you want to break it up, one of your checks every month would be $200 and one of your checks would be $150. If you're paying it all to him, that is how it would break down. Is that perfect? Is that doable for you?
Yes.
Yeah, I should be able to do that.
Okay. So what I will do then, and so it sounds like you would prefer to pay him directly rather than the child care facility?
Yes.
Okay. Is that okay with you, sir?
Yes.
Okay. I will do up a bench order that lays this out. I'm obviously not going to specifically indicate that it has to be paid 200 and then 150, but I will, for your benefit, Ms. Smiley, put that in as an example that was discussed at the hearing. But in reality, we just need to make sure that $350 a month is paid.
$350 a month. Okay, I can do that.
Okay.
Thank you.
Okay. Anything else the parties needed to address before this court today?
No, Your Honor.
No,
Okay.
Your Honor.
Okay. Well, I'll get those orders taken care of. They'll probably be filed with the clerk. I'm on docket all day today, so probably tomorrow or Friday at the latest. So if you want to get a copy of that bench order, you can reach out to the clerk and ask for a copy of it by Friday. And do we have Ruben Kamba with us?
Thank you.
All right. Thank you both.
Oh, son of a.
I have another experting matter, Your Honor.
If Ms. Westling, you need to mute yourself. I'm just going to mute you. Folks, if you're not actively in front of the court, please mute yourself. Okay, so when we were together last, Mr. Kamba was present, and I reserved ruling on the contempt because there was an issue of whether Mr. Kamba's, he claimed his employer had been garnishing, but Ms. Kamba hadn't been receiving it. So I was giving you all time to work that out. We'll talk about Mr. Kamba's motion for contempt, but he's not here. So I probably know the outcome on that case. So Ms. Kamba, as far as your motion for contempt on the child support payments, where are we at?
I mean, he's still behind a lot. Dennis hasn't gotten back to me, but Dennis did get a hold of me after I got out of court and say that there was something going on with his work due to him having multiple child cases going out. They had to figure out which child support needed to be taken care of. So they have figured out that all situated. So I have received payment. So I was willing to give him until like October, the end of October, to make sure he can consistently make payments before, I went further with this contempt, because I understand that if he was trying to make payments and due to him having 4 children and child support trying to take it out and figuring out which kid it goes to and it all a big mess and now it being fixed, I'm not going to be like a total rude person, and I understand. So if he can continue to make payments through October, then I would like to dismiss, I think that's the word, this contempt, because there's no reason for us to keep going.
Okay, so you had, in your original motion, you had indicated there was about $4,000 owed in child support. Has all of that been paid, or are you just kind of slowly receiving money?
Oh, I am just slowly receiving money because 2 years ago he
Okay.
assaulted me, and then he decided he just didn't have to pay for Gabriel. And then finally we got divorced, and they finally put it in orders that he had to start making payments, and he still didn't. So
Okay.
that's why at that point I made contempt.
Okay, so what I'm going to do on your motion for contempt, since he has made some payments, but not all, I'm going to continue to reserve ruling until we get to a next court date. How far out were you recommending we review this to decide if you want to dismiss your contempt motion?
I mean, now that everything's situated and hopefully his work is going well, I mean, he's not here to answer any of these questions I have. Maybe till the end of October.
Okay. Let's do, let's set this for November 1st.
Okay.
That'll give 5 weeks for you to figure out if this, you know, if you're actually continuing to receive money. So I'll reserve ruling on your contempt motion to November 1st. And then I'm just going to go to his contempt motion, which appears to be allegations that you've withheld visitation due to child support. I'm going to go ahead and deny this motion since he is not here.
I didn't even get that.
Oh, well, I'm going to deny on 2 grounds then. If you haven't been served, it's not properly before me, but also he has failed to appear today.
Yeah, the only one I got is that I missed the days where I first started, and I wasn't understanding what was the plan, so I missed that day. And then Gabriel started school.
It's
and
okay, ma'am. I don't need argument on it because I have signed off on a denial of his motion for contempt due to lack of service and lack of appearance today. Okay, anything else you need from the court on your matters?
No, what time is court on November 1st?
Same time as we started today, 9 a.m. It'll be the same Zoom docket, family law, self-represented A. Ms. Fellows is
Okay, thank you.
on this
Yep, you're
one.
welcome. Yes, Your Honor.
Okay, let me just pull this up. I have this on for review hearing for compliance of treatment and video visits. When we were together last, I did leave visitation kind of status quo. Maybe first I'll turn to Ms. Fellows to fill me in on where we are at, and then I'll turn to the parties.
Yes, Your Honor. I have some great news to share. I'm thrilled to say that the father is fully in compliance with his DV treatment and with his parenting class. He started DV on 8/16, and he has made sure that his provider is providing me with compliance reports. And then his parenting class, it's a 14-week parenting class. He started on 6/27. It is an MRT curriculum, moral recognition therapy. And it sounds like that's going really well. He had a session last night, and his provider emailed me saying that he was present and he's doing extremely well. Both providers are saying that he is engaging, participating, and doing the homework and things like that. So I am exceptionally thrilled to share that with the court, and would say kudos to Dad, to Mr. Kiyoshi. Regarding the visit, my understanding is that they continue going well. The supervised visits at parents' place, they continue going well. And I have some thoughts about trying to move forward with the visitation. I would like to see at this stage some unsupervised visits. I am wanting them to be somewhat restricted still, but be allowed to be unsupervised. So I would, my thought is to basically do the 2 hours on Tuesdays, basically same time, because that seems to work for both parties, and have that unsupervised. that he provide me, the GAL, with an itinerary of where he's going to be during the visitation. So that way I could potentially do a drop by, just kind of observe and things like that. And do that for a period of time. He did just start DV treatment in August, so he's about a month and a half into it. So we'd like to see a little bit more. But I would think, my thought was that's a good starting point. And would like to basically see increases probably at a pretty good forward motion, since he is in treatment and we are moving forward. So that's my thought.
Well, I think overall, Mr. Kiyoshi, that's great news. So thank you for putting in that work. Ms. Vaughn, let me first ask you, obviously, you know, this is kind of a step-by-step process. How are you feeling about the recommendation to allow the 2 hours on Tuesdays to go unsupervised with itinerary given to GAL for now?
So we already use our family wizard. It was ordered previously by Commissioner Nelson. So I think that I should also receive an itinerary of where they're going to be, just so I have tabs on my child. That way they're not just, you know, because if he wants to leave, say my kid doesn't want to spend more than 30 minutes at one place.
Can you speak up? Just, I'm having a hard time hearing you. Can you speak up a little bit?
Sorry. We already have communication through our family wizard in regards to Corey. So I think the itinerary, Beth has access to our family wizard as well, to our account. So if he can just put the itinerary to me and her on our family wizard, then if anything happens, you know, my kid maybe doesn't want to stay at this one place for 30 minutes. Maybe he's not having a good time there. Then he can communicate through that, letting us know if he's going to be moving places in real time, rather than calling one of us up saying, hey, he doesn't want to be here. What do I do? So as long as there's that communication, I don't have a big issue with it being unsupervised. We haven't really had very good communication in the past, so I would like to improve between the two of us. And in doing so, there was a previous bench order for no contact and all these things. I would like that to be lifted. You know, barring he continues his DV classes accordingly and whatnot, it shouldn't need to come back into place. I want to see that we can communicate for the sake of our child going forward as well. And I do agree that I think 2 hours is reasonable, unsupervised. Same, it doesn't have to be from 11 to 1 on Tuesdays. I'm free all day Tuesday. So time-wise, it would be up to him. However, I do feel it should still be restricted as well, meaning I don't think he should be allowed to bring any guests or family members to these visits for at least a little period of time, so we can see how he does with Corey on his own.
Okay. So I'm going to come back to Ms. Fellows in just a minute. Mr. Kiyoshi, you've heard the GAL's recommendations to, you know, through our next review date, at least. And like I said, this is step by step, but at least through our next review date, given the good work that you're doing, go change your Tuesdays to unsupervised time instead of supervised. I think at this stage, and this will not last forever, but at this stage, I think that the court would be inclined to have you send the itinerary through our family wizard so everyone can see it. Are you in agreement with that?
Yes, that works for me. So I mean, I do have one question though.
Yes.
So if I want, so I can't bring my niece, his cousins, to play with them. I understand there's a no contact order. I'm never gonna be near her. I'm there to see my son and my son only.
Yeah.
I don't see why I can't bring his cousins to see him or other family to see him. As long as I stay away.
Yeah, here would be my recommendation. So I'm looking at a bench order from March 3rd. And honestly, I haven't looked to see, do you all have a standalone no contact order as well? Or was it just Commissioner Nelson's bench order?
Just the bench order.
Okay, so it sounds like Ms. Vaughn wants that no contact to end, correct? You want that. So right now the bench order states that service of documents have to go to the sister's house, and that Mr. Kiyoshi is not to come within 1,000 feet of your home, your vehicle, or your workplace. Are you wanting both of those conditions to be dropped?
Yes.
Okay. I think that, so Mr. Kiyoshi, there would not be that no contact in place any further at the request of the petitioner. Okay. So What I would be inclined to do just until our next review date is to, per the GAL's recommendations, change your Tuesdays to unsupervised visits. Until our next review date, I would say, for the benefit of your relationship with the child, just have it be the two of you. I don't think bringing in additional family members while you're reestablishing this unsupervised time would be a great idea anyway. And then when we have our next review date, we can talk about implementing other family members back into the relationship. Is that acceptable to you?
Yeah, that's fine, Your Honor. Thank you.
Okay. Ms. Fellows, I can do bench orders to that effect. Is there anything else you would want to see in those orders or to address today with the parties? And then we can set a new review date.
I am in total agreement of it just being the father and son, that it is really needs to continue just to be the two of them, especially going unsupervised out into the community and stuff like that. So it will be really different for dad to really interact with his son and things like that himself. There is also the issue of the exchange point. I had talked to the mom and she suggested Youth and Family Link. There's a parking lot there. And that would be a good place for them to do the exchange. And with the protection order from that bench order dropped, then they should be able to do that.
Okay. And did you say it's called Youth and Family Link?
Yes.
Okay. Do you both know where that is?
Yes.
I do not, and I'm assuming it's in Kelso. Is there any way we can make the drop-off point halfway between Olympia and Kelso?
So part of the going unsupervised that I discussed with Beth was that he stay in the Kelso Longview, Cowlitz County city limits.
Yeah. Mr. Kiyoshi, you've been coming to Kelso for the supervised visits, correct?
Yes, ma'am.
Yeah. I do think that makes sense. I do think at least until our next review date that you should remain in the Kelso Longview area for those visits. And then the Youth and Family Link, I can get an address for that for you all and put it in my bench order. I'll put that address in there. So I will create a bench order that incorporates these elements. It does lift the no contact. It allows unsupervised visits. It indicates that the itinerary, and I'm going to be honest, I'm not going to, if the itinerary says at 2:00, we're going to be at Papa Pete's, and then at 2:30, we're going to Target, but Target happened at 2:50. I'm not going to be so militant about the timing, but more or less just that overall 2 hours, please be where you say that you are with the child. Okay.
Yeah, sure.
Okay. And then let's set a review date. Are we thinking maybe about a month out? Because then we'll get new progress reports for DV and parenting.
Can we do November 8th by chance?
That works for me because by then we'll certainly have September and October's compliance reports with treatment. So, Mr. Kiyoshi, does November 8th work for you?
That works.
Okay. And Ms. Fellows?
Yes, that works for me.
Okay. So we'll do November 8th at 9 a.m., same docket, and I'll get that bench order like I told other parties. Today is a busy day, so I may not get it done today, but I should have that in your court file by Friday.
Your Honor, it just slipped my mind. I do have a vacation I'm taking, and I'm going to be gone from the 8th to it's going to be a week, the 8th to I think 16th.
16th?
Yes.
So that would put us into, do we have docket the day before?
Can we do it at the end of November?
We do it on the 22nd. So that we could put you to November 22nd. That's the day before Thanksgiving. I don't know if both of you would be free.
I can do that, Your Honor.
I can also do that. And then I had one other matter I wanted to address.
Ms. Fellows, would that work for you?
Yes, it does, Your Honor. Thank you.
Okay. All right, Ms. Vaughn, go ahead.
So at the beginning of all this over a year ago, I had one specific request. His father has possession of a box of mugs. I know that sounds silly, but they are my late father's. And I asked for him to locate them and have them returned to me multiple times, which he said he would work on, and it hasn't happened. So I would like to get that back if that's possible.
I don't have anything in front of me about this. I believe you when you say you requested it. I know your case has been going on since well before I was involved. Mr. Kiyoshi, is this something that you know about and something that you have?
She's asked about it. I gotta find the mugs. I moved up here pretty quickly, so my son is what I'm here for. I'm not here for mugs.
So see if you can find those. It's in the clerk's minutes now. So maybe when we're back on the 22nd, the two, and because the no contact is now dropped, the two of you can have some communication about that. Okay.
Yep.
Okay.
Yes, Your Honor.
All right. Thank you both. Keep up the good work. You're doing all the right things, sir. Westleen.
Thank you.
Thank you.
I'm here.
Okay. So I have, this is a case where you all were in front of me August 16th. This is a case where there is an allegation of a significant payment that hasn't been made per a CR2A agreement. Let me ask the parties where we are at.
Yes. Can you hear me?
Yes, I can, Ms. Westling, go ahead.
He got me the money for the house, the 150, but the other two have not been addressed yet.
Okay. Well, that's good news at least.
Yeah, it is.
Okay, so what date did you receive the 150?
I don't know, like a week and a half, 2 weeks ago.
Okay. Well, Mr. Westling, good job on that. I was worried that we were going to be having to address all of the issues. So I think that's great news. That's a large amount of money. I'm glad you were able to get that paid. What I had wanted was, I had granted a 30-day extension to make a $70,000 payment. And then I said we'd deal with the remaining issues. I'm going to find today that, you know, by my math, 150,000 is more than 70,000. So
Well, it's
we're at
supposed
least
to be 150, but the way he put it into the divorce thing, I got 70, then 84 after he died, which I thought was kind of ironic. But that's the only way they would give him the loan was the whole 150.
right. So you did receive $150,000.
Yes, ma'am, I did for the house, but the other two were not addressed.
And the other two, I believe, are the
LPO.
or is it the retirement account?
Yes, ma'am.
Okay. So, Mr. Westling, what do you want to tell me? My inclination is because of you are in substantial compliance with what I ordered last time. You've paid more than I ordered last time. I'll probably just set a continued review date. So what I'm looking for from you is when you think those other payments could potentially be made.
Can you hear me okay?
Yes, I can.
Okay. I filled out the paperwork for that a month ago, and I called Beard Financial this morning to ask where we were at with that, and they said that they were waiting from the financial institution to send paperwork for Nancy to fill out on what she wants to do with the money.
The retirement account?
Yes.
Okay.
So it should be, she said it should be coming any minute. Right now, the whole thing, my whole account is frozen and nobody's receiving any money out of it. So it should be any day, she said.
So I'm just seeing, okay, changed to 150. The 70,000 was changed. So other than the retirement account, Ms. Westling, I'm just looking at the CR2A agreement, and I know there were some changes made. What's your understanding as to what else remains to be paid?
I really don't know. I know that we're supposed to get half of the LPO.
Yeah, that's half of the retirement account.
Yeah. And then the other one, he's the one said that he'd just give me the whole thing, which I didn't understand that, but.
Okay. What if we do this? Let's set a review date for 30 days out to check the status of the retirement transfer. I'll just continue to reserve ruling on the contempt, but what I'll find today is that there has been substantial compliance made towards payment of the CR2A agreement. Okay, so if we set this for October 25th at 9 a.m., would you both be available?
Yes,
Okay,
if I'm still here.
well, we certainly hope so. And I appreciate you both being here today, waiting for this long docket, and Mr. Wesley making some real progress on this. Thank you. So Mr. Teft, what can you tell me about any talks you've had with, have you been in contact with your attorney? I know Judge Basher had assigned you a public defender.
So, can you hear me?
Yes, I can.
So, I've been in contact with the clerk administration, and they said they're working on their end to find me one. But also, they permitted me to reach out to find one that may work for me, and the court would be willing to pay them. I reached out Friday to an office, so I'm waiting a call back this week. Be calling them again this week as well.
Your Honor.
Just a second, ma'am. Hold on. So, Mr. Teft, this is the same thing that you told me when we were last here on September 13th. And I told you to contact Office of Public Defense, not court administration. So my notes specifically are court.
Yeah, I called them too.
Hold on, sir, don't interrupt. Court instructs Mr. Teft to contact OPD directly. Have you called the Office of Public Defense?
Yes, and they referred me back to the clerk, to call the clerk, because they didn't have they couldn't find the information that I had given them, you know, as far as this case.
Oh, they were not able to. Okay. Thank you. I appreciate that update. So, Mr. Teft, the clerk has given me an update that Office of Public Defense, for whatever reasons, whether caseloads or conflicts, is unable to represent you. So you are correct in that they are seeking, we're looking for another attorney who can represent you on the potential jail sanction. So the only thing I can do at this time is set over the jail sanction hearing until you do have representation. I'll get that date here in just a minute. But I also see that Ms. Tech, you have filed a new show cause motion to be heard today. So let me just get there.
Yeah, because Michael hasn't made no attempts to make no payments whatsoever. And I feel like with this court thing, it's just, he's just keep trying to push it off and it's ongoing.
Well, ma'am, okay. So I do have your new show cause motion with the past due spousal support for September. Thank you for filling it out correctly this time, where you just did the current month of September's support for $650. The only thing I can do, ma'am, and believe me, I understand your frustration. I'm equally as frustrated that we can't get an attorney on board right now, but because the only sanction left in my toolbox is a jail sanction, he absolutely has the right to have an attorney present before I make that ruling. So I am going to set both the current contempt motion that you filed for the September payment, along with the prior contempt orders. I'm going to set them both over to a new date so that he can have the benefit of counsel. I'm going to do it for 2 weeks from today. That'll be October 11 at 9 a.m. And then let me just check with the clerk. Do you know, so is there anything more Mr. Teft needs to do, or is it just our court finding someone to take it?
Terry and see
Okay,
progress.
okay,
That's what I'm waiting for too.
perfect. Okay. So Mr. Teft, do you have the contact information for Autumn Terry?
Yes, that's who I spoke with last week.
Perfect. So I'm being told by the clerks that you should reach back out to her for a status on whether she has found someone to represent you. Once I am off docket today, I will also send her an email asking for a status update. And then we'll be back on October 11th at 9 a.m. Okay.
Since it's October, we gotta be back. That means I will be filing another contempt for October too.
Correct. So if you don't receive October payments, then I assume that you will file a motion to show cause for October.
Okay.
Okay. So you all were in.
All right,
Thank you both. Judge
Alrighty.
Basher, it looks like on August 30. They appointed a GAL back on August 2nd. And then it looked like Judge Basher wanted Mr. Perkins to provide some additional information to the GAL. It sounds like that probably did happen because the September 6th review hearing was able to be taken off the docket. So I guess maybe first I'll turn to Mr. Lawrence for an update on where we're at.
Well, Your Honor, I've had a chance to meet with both Tanya and James at their respective homes. James lives with his sister in Wilsonville, Oregon. At the time that I met with Tanya, she had an apartment in Vancouver. And during my interview, I discovered that she and her husband were considering moving to Haslett, Texas. And that move occurred on September the 16th of this year. I had a chance to have a Zoom interview with Tanya yesterday afternoon, and she showed me around the house. It's a 3-bedroom, 2-bath, 1-story home. Her husband was transferred. He worked as a truck driver for J.B. Hunt and was transferred to Texas. They have left Clayton, the 2-year-old child, with James, and James is currently the physical custody of parent in the matter. And that's the status at this point. However, Ms. Johnson is requesting the ability to visit with Clayton. She's had video interviews with him. Being only 2, he has a short attention span, so those don't normally last more than about 10 minutes. But Ms. Johnson is willing to pay for her to fly to Portland and pick up Clayton and then return him to Haslett, Texas, and then fly him back. And so she's requesting that the court allow her to have an extended visit with him at this point until we can get all this sorted out. It went from a traditional GAL investigation into one requesting an out-of-state move.
Mm-hmm.
And so it's going to take a little more time to put this together.
Right. Oh, thank you. Let me just look here. Okay. Then it doesn't look like, I know there's been lots of proposed orders and I just don't see anything that's been acted on, which is probably why I'm just going back a little bit further in this case, just to see if the out-of-state issue has ever been dealt with. It looks like Mr. Perkins did request some limitations regarding out-of-state, but it was not signed. And then that's when I asked for input from the GL prior to placing temp orders. Let me turn to you, Mr. Perkins. I don't think I'm in any position to make any long-standing rulings on visitation, but what would be, while we're kind of working through this review process with the GAL and pending the GAL's report, what is your request of the court regarding any visitation Ms. Johnson has?
Yes, Your Honor. Currently, with her being that far out of state and with my concerns about her current husband, along with a 2-year-old traveling on an airplane, I would request that if she does have visitation with Clayton, that she travels to the Portland, Vancouver area and has an extended stay here with her family members or something to that effect, to where she can visit with him here. I would strongly be opposed to having him travel to Texas at this time without further investigation being done by Mr. Lawrence.
It sounds like you're not opposed to visitation where she is to come here to Portland, Vancouver.
That's correct. I have not been opposed to her having visitation up until her recent move. So if she was to be in this area, then I would allow visitation. But like I said, I'm at this time opposed to my son traveling to Texas.
Yeah, understood. And Mr. Lawrence, I think that's what you were proposing, or at least discussing. I don't know, proposal might be a strong word, but discussing Ms. Johnson coming here for any visitation.
She had wanted to come to the Portland, Vancouver area in order to take physical custody of Clayton and then returning with him to Texas to be at her home. And then she would again do the same process to return him. So he wouldn't be on the airplane all by himself.
What are the concerns? I'm just hearing some concerns about the husband in Texas. Do we know anything about what those concerns are?
I do not know anything. I mean, her husband was in the apartment living with her when Mr. Perkins allowed visits in Vancouver. And so this is, I haven't had a chance to run a background check on her husband at this point.
Okay.
But I can certainly do that.
I think let's discuss that. So here's my concerns. I don't think I have enough information to feel comfortable with child being taken out of the state of Washington right now, or I should say Oregon, if you fly into Portland and you're staying in Portland for the weekend. My concern is I don't want to end up in a scenario where we lose jurisdiction over the child because the child ends up remaining in Texas and then Mr. Perkins can't get child back here. And I just don't even want to go down that road. So until I know more about all the factors in play here, I would like to, I think the bench order I'm willing to put into place until our next review date is that Ms. Johnson's allowed visitation in the, I think, and just for sake of keeping it in the state of Washington, I'm going to say Clark County, Cowlitz County, visitation physically here with child, but the child's not to leave the state of Washington at this time until further review. And
Your
then,
Honor, can I say something real quick?
Go ahead, ma'am.
I don't have family members to stay with in Washington, so it would cost air flight and hotel for me to be able to see my son there.
Yeah. And I certainly understand that. I'm just, that's what my bench order is going to say. So until our next review date and I have more facts in front of me, it seems like this is there's kind of little pieces of the puzzle coming out at a time. So for the best interest of the child, especially only being 2 years old, I am going to allow visitation, but it has to be in the state of Washington in Cowlitz or Clark County. I understand that may not be feasible, but that'll be my order until our next review. Let's go ahead and set a 30-day review date. If that works, I could do October 25th or November 1.
Either one worked for me, Your Honor.
Okay. Mr. Perkins and Mr. Lawrence?
Both work for me.
I can, those are Wednesdays, correct?
Correct. It'll always be a Wednesday at 9 a.m.
Okay. Yeah. Yes, Your Honor. Either day will work for me.
Okay. Mr. Lawrence, for purposes of investigating this, is 5 weeks better than 4 weeks, or do you have a preference on that?
No, Your Honor, I have an access to a program that does criminal history checks nationwide on my computer, so I can do that within just a few minutes.
Okay, so let's do October 25th. So I'll specifically also make a note that we'll revisit any out-of-state visitation at that time. Okay, anything else for the parties today?
Is there
Not for me,
anything
Your
I
Honor.
can do?
Ms. Johnson, I would just say keep in touch with Mr. Lawrence at this point, okay, between now and the next review date.
Okay.
Okay. All right, thank you all. You're free to log out. Megan McCafferty.
Yes.
Okay, thank you, sir. I know you've been waiting a long time in that iPad booth. Thank you for hanging in there. So as I see it, we have had this on for review of order, but there was an issue with service when we were all last in front of a judicial officer, Judge Fassett. I think at that time, Mr. Havens hadn't yet served the other party. So we have this notice of hearing that Mr. Havens filed to review parenting plan and child support. I see that it was served on September 8th. Let me ask Ms. McCafferty, were you anticipating filing your own orders, or are you in agreement with these, or where are you at?
I don't mind dropping the child support. That's not a problem at all with me. I am kind of concerned on why I have to wait for a visitation and I would only be able to see her on a Saturday. I've literally had my daughter since the day she was born up until a couple of months ago, and when he took her from me, and he hasn't responded to anything I've said. He hasn't been willing to let me see her at all.
I'm just looking through the history of this, and let me ask this question. Is the child receiving any sort of state assistance?
No.
She does get Social Security. However, right now I'm not getting Social Security for her.
And Mr. Havens, and I'm talking about medical benefits, TANF, anything like that?
Medical right now is the only thing that I'm aware of.
Say that again.
State medical is all that I'm aware of.
Okay. Ms. Looney, since I have you here, I hate to put you on the spot, but is this a case where they would need to serve your office?
I am checking that right now, Your Honor.
Okay. I also see, I'm just looking at the original. There was an order of default entered against Ms. McCafferty on July 6th. And then I think, Mr. Havens, you met with a courthouse facilitator to go over these documents.
Yes, I did. And she still hasn't taken the drug and alcohol evaluation or mental health evaluation, and hasn't taken a hair follicle test yet either. So there's no proof to me that she's clean and sober.
And I mean, I could argue the same thing with him. So,
well, so yeah, I just want to hold on. And I mean, here's the thing, Ms. McCafferty, this court back in July issued a default against you, and basically allows this court to approve final orders without the other party's participation because you didn't appear or file response.
yeah, I've been unable to make it there. I lost my car. I've been going through my own personal issues, and I have no way to get anywhere to do any of these things. I have another child who I have here in my full-time care as well.
Thank you, Your Honor. I was able to check, and our office does not need to be involved for this case.
Okay, and I did see, Mr. Havens, that you did submit an affidavit of filing with prosecuting attorney's office back on August 11th. So what I'm going to do, so Ms. McCafferty, let me ask you this. You've had a chance to review these proposed orders.
Well, the paperwork that I got, I didn't see anything saying that I had to go and get any of these tests. I was not even aware that that was even in place yet, which I'm totally fine with doing.
But can I also request that he get a hair follicle test to make sure that she's
no, there's a default issued against you, so you can't request that. So basically he's entitled to submit these orders to me. What I'd like to do, just because of, we're not gonna have time to go through these final orders before I need to end docket. I'm gonna, are you free to come back next week, next Wednesday at 9 a.m.? What I'm gonna do is give you my oral ruling. In all likelihood, I'm going to sign these orders because of the default, but I'd like to review them and just make sure there aren't any questions I have of you. Ms. McCafferty, you'll be able to put any objections you have on the record. But again, I'm just going to be really clear that there was a previous default entered against you. Mr. Havens, would you be available next week at 9 a.m. to finalize this matter?
I'm available anytime you need.
Okay. And Ms. McCafferty?
So after I go through all of this process.
I'm just asking, are you available next Wednesday at 9 a.m.?
Yes.
All right. I will see you both back here on October 4th at 9 a.m. I will give you my final ruling on your final orders or on Mr. Haven's final orders. Okay. Thank you both. This is one where. Thank you. I think as the parties pointed out, and specifically you, Mr. Adams, that there are pending actions in Pacific County. When I was with you all last, I indicated we would need a conference to determine which court truly has jurisdiction of this case. We have reached out to Pacific County. That matter is pending. So where the two courts talk, that matter is pending. So all I can do today is just set you a new review date pending the outcome of our discussion with Pacific County.
Okay, Your Honor.
What date would work for you? It's my judicial assistant let me know that they have reached out to Pacific County. There is no set date yet. It just states pending. So my recommendation was we do a 3-week review on October 18 at 9 a.m.
That's fine. And then I have a question, Your Honor. Since Ms. Linden didn't comply to what Pacific County has said, I haven't been able to file any type of papers to proceed to show the courts what's going on. And I'm just curious, is there any papers that I could file at this time, or do I have to wait?
Yeah, I can't give you legal advice, but what I can say is if you believe she is in contempt of Pacific County orders, then you can file contempt motions in Pacific County.
Okay, Your Honor.
Yeah. Okay.
I have somebody in Pacific County that I'm willing to meet with that's helping me with the paperwork. Okay. So I'll be able to call her today after this court and set up a date to finalize any papers that I need to proceed in Pacific County for that.
Okay. I'll see you both back on October 18th at 9 a.m. Ms. Linden, can you just confirm that you've heard the court?
Yes, ma'am, but I will not be able to do it the 17th, 18th, or 19th.
Okay.
I have character stuff going on.
Are you both available on October 25th?
I am available anytime, Your Honor.
Okay. Ms. Linden, the 25th work for you?
Yes, Your Honor.
Okay, we'll see you back October 25th at 9 a.m.
Thanks, Your Honor.
Okay.
Thank you.
Okay. That was intense. Okay. Last on my docket, and we're going to have to be real quick, so this may be something we set over, but I'll hear from the parties. This is Zach Biskig and Megan Gibson.
I'm here,
Your Honor. Thank you. I know this has been a very, very long docket. My apologies to you. Because you are the most recently filed case, as you can hear, some of these cases have been going on since 2021. I know yours probably feels like a long time. You filed in July of 2023, but as you can see, you are the most recently filed case. We were together on September 13th, and I think at that time we were discussing mailing of evidence to the other parties. I'll get some brief input from you, but then I will just have to give you a new court date.
Okay. I was able to email the documents to Mr. Bissig, as well as turn in my declaration to the courthouse. You should have the proof of mailing or hand delivering in the system, as I did turn that in last week.
And again, I have your temporary family law orders here. Have you also served these on the prosecuting attorney's office?
I was unaware of having to serve to prosecuting attorney's office.
Okay. Go ahead, Ms. Looney.
Well, Your Honor, we have already sent out proposed child support worksheets to the parents. We're aware of what's happening in the case. We're just waiting for a temporary order to be entered so we can request a child support hearing date.
Got it. Okay.
Your Honor, there is already child support ordered towards Mr. Bissig to pay. He is now $1,350 in debt to the state.
So, yep, hold on, ma'am.
$1,350.
Okay, so, sir, what is your position on, have you now received the proposed temporary orders?
Yes, and I also responded back to her.
Did you file your own proposed orders?
Yes, I'm the one that started it all.
Sorry, I'm having trouble understanding you. You did or did not?
Yes, I did. I was the one that started it all.
Okay, maybe I don't have those as originals in front of me. Are you talking about, nope, those are hers. The July 25th proposed parenting plan, is that what you're talking about?
Yes, I did that one.
Okay. Is your current request the same as what you requested in the July 25th parenting plan?
Yes, for my temporary one.
Okay. So I'm going to do this just because of our time. I'm now 40 minutes behind starting my next docket. I'm going to give you all a new court date. Do either of you expect to be filing any additional documents before I make a decision on your temporary orders?
No, I don't plan on unless she does something for me.
Okay. Ms. Gibson, do you intend to file any additional documents before I rule on the temporary orders?
No, Your Honor, I've submitted everything I needed to.
Okay. Let me look and see. I could put you on next week, but let me see how many we have already.
There is just one thing, Your Honor, with
Just hold on, ma'am. Just hold on. Okay. Right now we're sitting at 9 cases next week. That probably will go up a little bit, but we're not going to be anywhere near the 21 cases we had today. So since you all have submitted all of your paperwork, I'm going to just bump you over 1 week to October 4th at 9 a.m. Does that work for you, Ms. Looney?
Your Honor, the state's request would just be if we could set it out slightly longer. That would give us time to get a child support order proposal out and do everything on the same day.
Perfect. Let's do that. What are you thinking? 4 weeks to give time for service and any response?
3 to 4 weeks should be fine. We could get the order out fairly quickly. We'll be using the same worksheets we've already sent out to the parents with our proposed worksheets and notice of parents back in August.
Okay. So to the parties, I'll give you the choice between October 18 or October 25th. What works for you? Mr. Bissig?
The sooner the better, please.
Okay, we'll do October 18th. Ms. Gibson, does that work for you?
I'll make it work to the best of my ability.
Okay. So October 18, 23 for review of the temporary orders. And then Ms. Gibson, you had a question?
It was just about setting it over because I do have a job and I work mornings. I will be working that day, so I'll just have to try to see if they can get my shift covered out.
Yeah, understood. If you run into issues with work, we certainly don't want anyone to lose their job over having to come to court. If the 18th is not doable for you due to work, please reach out to court administration and we can handle that, okay?
Okay, yeah, I'll talk to them because I've already missed 3 days for court already. So
yeah, I mean, as you probably heard from a lot of the parties here,
yeah,
they've been in court for years. So
yeah, so
this is a marathon, not a sprint, unfortunately, and I feel your pain. I'm not, trying to diminish that at all. But again, I think the remedy here is if it is a problem for your work, just let the court know and we can work with you.
All right, thank you so much.
Okay, thank you both.
I got a question real quick.
Okay, go ahead.
Since it's taken so long, I would like to be able to visit my kids. Is that anything possible?
Yeah, I'm not going to make any rulings right now on visitation. I'm going to just reserve all of it for October 18th, okay?
Okay.
All right, thank you both. You're free to log off.
A week out.
All right, I'm going to end.